Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. And this is our Thursday community conference call. One Thursday, we do it on LinkedIn audio, and the other Thursday, we do it on this bridge, which you're calling 202-800-8394. The calls are always at 12:30 p.m. Eastern Time. I want to make it clear that we are not creating an attorney-client relationship. We cannot guarantee the accuracy of the information. We do the best we can. So everything is being provided as is. And I hope to provide you some direction, but ultimately, please, this is not a substitute for an in-depth conversation with your lawyers. All right. So with that, let's get started. And the procedure is going to be as follows. In the questions that have been posted in the forums, forums.immigration.com, I have marked certain questions as frequently asked questions. First, I'll answer those questions. Each time I answer a question, I'll say, if you have any follow-ups on what we have discussed, go ahead and raise your hand. And that means you press *5 on your phone. But don't bring in any new material at that time. First, I'll answer all the frequently asked questions. Then I will answer the other posted questions. At some point, I will lock the conference because I want to make sure I'm able to answer the questions of people who are already here. And we may not have enough time then. If we keep the conference room open and people keep logging in, it becomes difficult to answer everyone's questions. So at some point, I'll lock the conference. Once I have done all the questions, there's 14 of them in total, then I will invite questions from people who are here, any new questions. And I'll make sure I answer all the questions of people who are here. Okay. So with that, let me get started. These calls are being recorded. They'll be made publicly available. When you logged into the conference, you heard all this. So all those disclaimers apply. Let me go on to the first frequently asked question. So EB2 versus EB3 visa filing, pros, cons, and priority date considerations. So the question was, my perm got approved on October 5th. I'm an Indian citizen. Priority date from the previous employer is 2012. So I'm current under the dates for filing chart for EB2 and final action dates chart for EB3. My employer's immigration firm insists on filing my I-140 485 under EB2 instead of EB3. Okay. So you may play this part of the recording for them. It is absolutely clear in the law. There is no doubt in anybody's mind that even if you have an EB2 approved case, okay, you can always file the I-140 under EB3. That's your choice. Nobody can challenge that choice. But does that mean that makes your I-140 and your perms stuck to EB3? No. What I normally do is whatever date is more advantageous, I would file that I-140. So for example, you are under EB2, I would file, if EB2 is advantageous, I would file EB2, otherwise I would file EB3 if that's better for us. Remember, you cannot upgrade from EB3 perm to EB2 I-140, but you can downgrade from EB2 I-140 to EB2 perm to EB3 I-140. Sorry, other way around. You can downgrade from EB2 perm to EB3 I-140. So when you have an EB2 perm, you can file either EB3 or EB2 or both. So it's not like that I-140 is going to terminate your case and you won't have a chance to go back to EB2. So I see no reason why we should not have you file under EB3. Would it be better to file your case under EB3 or EB2? What I would do is, if I were you, I would file for I-140s for both cases. I would file EB3 I-140, EB2 I-140, but I-485 I would file with the EB3 probably. That's probably what I would do. Okay. *5, if anyone has a follow-up question on what I just discussed, press *5 if you have a follow-up question what I just discussed. Okay. There is none. Let's move on to the next frequently asked question. I am scrolling on our, okay. So this is an important one. This question says, what is a 212A6C1 refusal of visa? So normally you would have heard of 214Bs or you would have heard of 221G. So these are all relatively straightforward situations. But when you have a 212A6C1 denial, visa refusal, it's a very serious issue because it's a permanent bar from entering the United States. This section of the law talks about fraud or misrepresentation in trying to procure an immigration benefit. Now, it can be a visa, it can be a petition, or misrepresentation at the airport or during a visa application. So it can be a written or oral misrepresentation. It's quite problematic because it's, like I said, a permanent bar, and the waiver is quite complicated and difficult. Okay, there is, first of all, very limited waiver available. So I'm looking at your question. Your entry into the US was denied a few months back. H-1B was cancelled. You agreed to that you will apply for a new visa. When you went for an H-4 interview later on, they asked you about the cancelled visa and they gave you a refusal worksheet, section 212A6C1. So if they have, when you say refusal worksheet, I'm assuming they actually gave you a denial or a refusal. If it is a worksheet and they're still asking you questions, I can see how that might turn out differently. But if it is a refusal based upon 212A6C1, it is very, very difficult to get around that. Okay. Now, typically what we do in these cases is it's a tedious, lengthy process and it often doesn't work. So I'll begin with contacting the consulate, trying to get some information from them. They will decline. I will send a detailed letter explaining that there is no problem here. In the meantime, I would have filed a Freedom of Information request with all the agencies that are involved in the process. Once over a few months, we'll get the results. Then we'll prepare a better letter, send it again to the consulate. Consulate will again say, well, we don't agree. There is fraud here. Next thing is we'll take it to the next process, which is the legal net. We take it to legal net and say your consulate is making an error. So these things are pretty lengthy. They can take many months, even a year or more, to try to straighten out. And there's no guarantee it will get straightened out. One of the cases that we did last year actually was settled in litigation, which was quite unusual. After we tried everything, we had them file a litigation and the U.S. Attorney's Office settled the case. So these cases are extremely difficult to win once you get stuck in this 212A6C1, which is fraud or misrepresentation in procurement of a visa or immigration benefit of any kind. Okay. *5. If you have a follow-up question, press *5. In about 5 minutes, I'm going to lock the conference because we have enough people here. If I keep the conference open, I won't be able to answer everyone's questions. So in another 5 minutes, I'll close the conference. Let me see if there's any other frequently asked question here. Oh, there were only 2? Okay, that was not too bad. Oh, there is a follow-up question from California. Okay. 1 second. Yeah, California, go ahead. I can hear you. California, go ahead. Area code 408.
Yeah, hi. Yeah, hi. Can you hear me?
Yes, sir.
Yeah. So I have a question. So my brother got an H-1B approval. He's in India,
Okay,
right?
stop. I'm not doing any new questions at this time.
Sorry.
I'm only doing posted questions and their follow-ups. Okay? So put your hand down, please.
Oh, okay.
Yeah,
Sorry.
once I'm done with the posted questions, then I'll take new questions. Please stand by.
Oh, sorry. Yeah.
Yep. Okay, so yeah, I might as well lock the conference, guys. We have enough people here. Hold on 1 second. That way I can make sure that everybody who's here gets their questions answered.
The conference is now locked.
Yeah, I locked the conference. Okay, now let's go on to our questions, posted questions. This is question number 3. I-485 status, job portability, and visa availability concerns. My priority date is March 2013. It was current in EB2 last year. Employer B's attorney filed for I-485 based upon previous employer's I-140 and without I-485J. How can they do that? See, look, I don't know what is going on here. Something is wrong. So if you get your I-140 approved from employer A, but you have never filed your 485, then you go to employer B and you file a 485 based upon employer A's I-140. That's crazy. Because until employer B gets their perm processed, then their I-140 processed, and transfer the priority date from employer A to employer B, only then you can file 485. The only other way to file 485 is if employer A is willing to take you back and you are willing to go back. Then also it will be based upon employer A's acceptance of your employment. It will not be based upon employer B. Employer B has to file their own I-140. So this whole thing is either I'm misunderstanding what you're saying or your lawyer has no idea what they're doing. So the previous employer had not submitted I-140 withdrawal. My attorney represented that employer B's perm was in progress. What? These lawyers don't know what they are doing, sir. Get a second opinion. How can you file a 485 while the perm is still pending? There is no exception to this. USC has accepted the petition and sent an RFE. This is going to get you into trouble. Okay? Because on the date you filed the 485, you did not have an I-140 approved through employer B. If this issue comes up, even 2 years down the line, they will deny your case, saying that you filed the 485 inappropriately. Yeah. So USCIS has not been able to, they have not really looked at your case. The day they look at your case, they will deny this. So I'm not going to answer the rest of the questions because I think this filing itself is incorrect. You definitely should maintain your H-1B because I think this is going to get thrown out. Oh, I don't think there is a misrepresentation here, which is your concern. It doesn't look like there is any misrepresentation. I would withdraw this 485 and refile it whenever the dates become current. Yeah, this 485 in my opinion is inappropriately filed. If what you have described to me is correct, this is inappropriately filed. It has to be refiled. Okay. Star 5 if you have a follow-up question. Press star 5. All right. Next question. Transitioning from OPT to H-1B to STEM OPT extension. Status and employment concerns. I was on OPT until October 1st. The company filed H-1B change of status. Case was approved. I-787, you mean I-797. You got your I-797 approval in July. You left that employer and they sent the withdrawal. Okay. It was delivered to USCIS July 14th. OPT expired. I've applied for STEM OPT extension. So if you applied for change of status, you are no longer on OPT. Again, there is something fundamentally wrong with this situation. If you are on the phone, press star 5. I would like to talk to you. Press star 5 if you are here. Okay. So there's something fundamentally wrong with this. I don't understand how you have, how you can be on OPT when you have received a change of status. I was on OPT until October 1st. They filed for change of status. Case was approved. In July, I left the company. Withdrawal of H-1B. I think you've been very improperly advised. Just because the H-1B was withdrawn, your change of status doesn't go away. Your OPT is over. You can only go on H-1B. How should I proceed? You do an H-1B transfer. Whether or not you can work in the interim, you need to talk to your H-1B lawyers. Let them look at your whole case. Worst case scenario, you go get a visa stamping and come back and start working. So I haven't kept track of all the dates, but the moment your change of status is approved, your OPT is gone because this was past October 1st. Okay? So something is wrong with the way you are understanding or being advised. *5, if you have a follow-up question on this, please press *5. All right. Next question is about H-1B work location amendments addressing remote work and future changes. My H-1 got picked up from a different employer than my current employer. My project is hybrid, but I've been working remotely. Okay. My work location is Austin, but I recently moved to Kansas since it's remote. My employer filed my LCA with 3 locations: office, Austin, and Kansas. Will there be any issues of having multiple locations? Well, I don't like to file multiple locations unless there's a real good reason. Okay. These are not too many locations, 2 home addresses and one office address. I don't think it's too bad. I think you should be okay. But I like to keep it quite tight. My employer also mentioned that if my mode of work becomes hybrid, there's no need for an amendment as my LC already has my Austin address. I agree. Will changing payroll from Kansas to Texas be sufficient in that case? Yeah, I think so. If you have the LCAs appropriately approved and they were filed as a part of the H-1B, you should be just fine. Press *5 if you have a follow-up question on this. Press *5. Okay. Next question is, we already covered that, 212A6C1. So we are about halfway there, 7th question. Changing jobs on L1A with pending 485 supplement J impact on green card. I'm on L1A. I have the I-140 EAD and AP approved. 485 was applied concurrently. Pending over a year, very good. I know it is recommended to continue. No, why is it recommended? See, once your I-140 is approved and your 485 has been pending 180 days, even the people who have got their EB1C approval, I'm assuming that's what it is, or any green card under EB2 or EB3, you can change jobs to same or similar job. So one thing that is confusing for people in L1A, EB1C situations is, I work for a group of companies. For example, let's say I work for the Tata group of companies. After 180 days, can I move to a totally different company? Let's say IBM. Absolutely. That's the whole idea. So you can move out of that group of companies as long as the job description is same or similar. You can do it anytime you want. And there is no problem with that. This is allowed by law. Okay. So I-140 must be approved and I-485 must have been pending 180 days. Okay. *5, if you have a follow-up question on this, please press *5. Question number 8. So F1 visa application marital status disclosure. Okay, ma'am, you must always tell the truth. Okay. If you try to conceal from the government that you are married, it will at some point become a 212A6C1 denial, which is a permanent denial, 212A6C1. Yeah. Permanent entry into the United States. You can never come back to USA. Always tell the truth. Whether or not your F1, F2 gets approved or not doesn't matter. You have to tell the truth. That would be my recommendation. Do not think that not disclosing is a good idea. *5, if you have a follow-up question, press *5. Question number 9. B1, B2 application during H1B 60-day grace period. Approval, rejection, and implications. How often B1, B2 gets approved or rejected during the 60-day grace period filed? What amount of money should one have to convince government that he can support himself? So, enough to cover your budget. So let's say if your monthly expenditure is $3,000 and you want to want to get it for 6 months. So 3,000 multiplied by 6 is 18,000. That money, or if your budget is covered. So for example, if you are living with the family member and you don't have to pay rent, then the budget will be decreased accordingly. So typically government doesn't really ask a lot about these situations, but they can. And if you have about 6 months survival money, you should be okay. As to whether it gets approved or rejected, I don't have any data on that. But in the current crop of B1, B2s that were filed during these layoffs, I have not heard of a rejection yet. Okay, I have heard of many approvals. If B1, B2 is rejected but already found a job, you will just do an H1B transfer and go get a visa stamp. That's all. Can one stay in the US during the time of H1B transfer, provided the 60-day grace period is already over and B1, B2 is also rejected? No. No. Because the moment your B1, B2 is rejected, you are now unlawfully present. And if you remain unlawfully present for 180 days, you are automatically barred from entering the US for 3 years. Okay? Be careful with that. Is there any B1, B2 premium process? I think there is. I'm pretty sure there is. There didn't used to be. Now it is. So you can do B1, B2 premium processing. Pretty sure. Yeah. *5. If you have a follow-up question on this, press *5. Question number 10. I-140 denial due to incorrect NOF address. I don't know what NOF is. Is it notice of findings? Grounds for appeal and responsibility. My NOF included the address of notice of filing. Included the address of U.S. Department of Labor. Yeah. So if you don't have the right address on notices of filing, I think there is nothing we can do with this. If you want to Google BALCA, BALCA, BALCA rulings or BALCA decisions online, you can see they have digested their opinions by subject matter. So somewhere in there, you will see subject matter like defects in notices of filing. When you click on that, you'll see the cases. So you can read a few cases yourself. As far as I remember, it is not possible to overcome this ground because it is written in the regulations what must be put in the notices of filing. Okay. Yeah, I think you have, Hardikji, take a look at the BALCA rulings. You should be able to figure it out yourself. If you're not able to, we can always set up a consultation for all your colleagues and you. Okay, I don't think there is any excuse possible when you have the wrong address. Sorry about that. Okay. *5, if you have a follow-up question, press *5. Okay. Considering an H1B to F1 trans, this is number 11. I think we have a total of 14 questions, if I remember correctly. No, 15. 15 questions. Okay, so we are now at question number 11. Considering an H1B to F1 transition, timing, I-140 and future employment consequences. So, I'm not sure if this question, okay, I apologize. I have an approved H1B beginning October 1st of this year. Haven't done my H1B stamping. Considering a PhD next year. Should I hold off on the employer filing for I-140 that might cause issues with H1B to F1? I would take a chance with this. I personally would. Although you are right in your concerns. My concern mostly is once your I-140 is approved, you get some additional rights that I would want you to have. Okay. And also remember, if your I-140 was based upon PERM, you have only 180 days to file the I-140. If you don't, your PERM is gone. Okay. So I would do it. I would do the I-140 filing if I were you. Is there any benefit to wait until I-140 is approved before changing from H1B to F1? Yeah, so once the problem is because you don't have a change of status. Let's see, did you get a change of status? I have an approved H1B. Oh, I'm yet to get. See, I'm not sure. One thing you haven't made clear is, Did you get a change of status? I am assuming that you did. So if you got a change of status already to H1B, you will not be subject to the lottery, even when you convert to F1. Okay? So you'll be fine there. But if you never received a change of status or a visa stamping, there is a question whether you are exempt from the lottery or not. So nobody can really answer that question. We've been able to get approvals with these cases, but who knows? Okay? But I think I-140 approval would be a good idea, at least in my opinion. Press *5 if you have a follow-up question on this. Press *5. Okay, this one is from area code 608, which is Wisconsin. Okay. Yeah, Wisconsin. Go ahead, please.
Hi, thank you, sir. So for this I-140, I'm the same person who asked this question. So for this I-140 approval, if I were to return to the same employer, let's say 5 years down the line, would this I-140 still be valid in any way?
Okay, hold on.
I'm just trying to understand because now there's the...
hold on. Let me answer this question. So I-140 is valid forever. There is no expiration date.
Okay.
I-140 filing has an expiration date. But once it is approved, there is no expiration date. As long as the same job is still open for you and you are willing to take it.
Okay. And it has to be with the same employer.
Absolutely. But if you wanted to change employers, hang on. If you wanted to change employers, two things will happen. One, you will carry the priority date of the old case with you forever. Okay. Number two, if your I-140 stayed unrevoked for 180 days after getting approved, you have the right to keep extending your H-1B with any employer until your priority date becomes current. So you have a huge advantage there.
Okay. Okay. Thank you. So I think it makes sense to even expedite I-140 through the premium processing options that are available now, so that I have enough time before I apply to the change of status. And just one last question I had, which was
one second. I had a preliminary question which wasn't clearly answered in your question. So did you receive your change of status to H-1B?
I mean, this automatically went into effect, right? On October 1st, I got my 797 approval.
So you got your 797. Did you get a I-94 at the bottom of it?
Yes, I did.
Okay, so that's good because I wasn't sure. So now I think it makes sense to me to file the I-140. And if you have difficulty converting to student status, I personally don't think you will, because as a practical matter, serious students are encouraged by the government. I know many cases like this that have been approved. I've been dealing with this, you remember, immigration law for 33 years. So I can tell you this, I think it's going to go through, but can I guarantee it? No. Out of the not filing I-140 and filing I-140, I would take the I-140 filing option.
Okay, thank you so much. And is there any limitation on when the I-485 needs to be filed related to the I-140? Because as per my understanding of USCIS regulations, what I understood is the moment someone files I-485, they've established immigration intent, so I would no longer qualify for non-immigrant visas like the F1 or the B1.
Hold on.
So
hold on. You have established your immigrant intent the moment you file the I-140, not the I-485. Okay. So despite that, I think you will get your F1. Despite that, I can't guarantee it, but I think you will. Okay. I gotta go on.
Okay.
All right.
Yeah. Thank you so much.
You're
welcome.
You for your time. Good luck. Okay. Next question. Let's see. This one is question number 12. H1 to B2 change of status, financial accounts, legal stay, future H1B. Can I keep my 1099 without doing any new transactions? What 1099? I don't know what Robinhood is. I'm assuming if it's stock trading, or should I completely deactivate the account? I mean, if you are doing day trading, you should definitely deactivate. If these are long-term investments, yeah, you can leave them there. if my I-140 and H-1B extension process is not completed in the next 12 months, what should be my best option to stay legally in the United States? You can apply for another B2 extension if you have a good reason for it. Can I apply for fresh H-1B lottery in the coming year on B2 visa? I thought you already were on H-1. Yeah, so why would you want to apply for a lottery again? You don't have to apply for a lottery when you go from B2 to H-1B back again, because previously you were on H-1B. So I'm not sure I understand your question. *5 if you are here. Press *5. All right. Yeah, okay, here you are. Area code 347, which is New York. Okay, one second. Let me come to you. Yeah, New York. Did you get a change of status already to H-1B or no? Hello?
Yeah, so I'm on H1B already.
So then you don't
Yeah,
have to
can
go
you
through
hear?
the lottery. There's no question of lottery, no?
No, I was asking if I don't get my I-140 approved or my H1B extension happened, can I go through H1B lottery rather than going to B2 extension one more time?
No, ma'am. You are not entitled to the lottery any longer. You already have an H-1B.
Okay.
Okay.
Okay. So
And-
I can just stay on B2 until I get a approval.
Yeah, you can keep extending your B2 if you're not able to get a job that you want. By the way, are you saying that
Okay.
your 6
No,
years of
I
H-1B are over?
actually-
Are you saying that?
Yeah, it is.
Oh, okay. That's a different case.
Yeah.
So your 6 years of H-1B are over.
Okay.
I thought you were still in the first 6 years of your H-1B. Yeah, okay. That was not clear. So
No, it's over and my I-140 is in process.
Okay.
My perm is in process currently.
when was your perm filed, ma'am?
Yeah.
When was your perm filed?
August.
August of
Just 2023.
2023?
Yes.
Okay. Yeah, you'll have to stay on B2 and you become eligible for 1 year extension in August 2024. But if the I-140 is approved before then you become eligible for extension then.
Okay. So I can extend it to 6 months more after 12 months?
Yeah, you can ask for it.
Okay.
I mean, there's no
Okay,
guarantee
yeah.
that you'll be able to, but you can ask for it certainly. And also remember that you are not subject to the lottery now. Okay? So you don't have to go, even if the 6 years are over, when you go from B2 to H-1B, it will be outside the lottery. Okay?
Okay. Okay.
All right.
I got it. Thank you so much.
You're welcome. Good luck.
Yeah.
Okay. Next posted question. Number 13. Exploring day 1 CPT. All right. Can I do a second master's? Did my first master's on OPT, on CPT, and can I do an OPT again? Not at the master's level. So OPT will only be available if you go to the next higher level. If you got your OPT at master's level, you'll have to go to PhD level. But can you do a second master's with CPT? Sure, you can. But one thing I'll warn you, I've always told people that even though CPT is clearly available in law, make sure that you are doing it in good faith and you're not just trying to drag the process so you can get work authorizations. So there should be, I mean, it's not required by law, but common sense will tell me that you should be able to show that this is a career progression for you. Okay, so for example, if you have a degree in computer science, now you are doing a master's in robotics or in automation or in control systems, so that you're becoming more and more specialized in the career that you want to go to. That would be my only recommendation. *5 if you have a follow-up question. Okay. Question number 14. Financial options for pending F2 to H1B, subcontracting and payment. I'm currently on pending F2 from O1. Okay. H1B can take up to 3 months to initiate filing. I received an offer as a subcontractor. Get the money in an Indian account in Indian rupees. Illegal. Ask the professor to give the money as a loan. Illegal. Work now and get paid once H1B gets approved. Illegal. All three of them are illegal. No, you can't do any of that. You can certainly borrow money, but you cannot do any of these three activities. Okay? If you take the money as a loan, then you shouldn't work for it. That is illegal. Star 5, if you have a follow-up question on this, press star 5. Okay. The last posted question is challenging AOS denial and priority date retention, lawsuit or fresh I-485. My ex-employer withdrew I-140, this is employer A, withdrew I-140 not due to fraud or misrepresentation. So this was Feb 2016. I did not receive any notice of revocation. When I joined new employer B, they were able to retain my old priority date. Yeah, that was not, because it was revoked prior to Jan 2017 when the regulations changed. Yeah, okay. USC has denied adjustment of status. You can try a litigation. I don't think, so what used to happen before January 17th, 2017 was, I remember 3 different periods. Period 1, when the moment your I-140 was approved, USCIS allowed you to keep your priority date even if the I-140 was revoked. Period 2, they said, oh, no, we can't do that. Under the regulations, if your I-140 is revoked, your priority date is gone. And this was the law before January 2017. And then the third period, they went back again to saying, oh, it's okay, we'll let you keep your priority date. So here's my problem. As long as this was working for me, I was okay with it. But when they said, well, the regulations don't allow it, I looked at the regulations very carefully. And if I remember correctly, my conclusion was, that is true. The regulations did not allow you to keep your priority date. So you can try a litigation, but don't be too hopeful that you will win it easily. Because I think the regulations at that time did not permit you to keep your priority date if the I-140 was revoked. That's the best of my memory. But you can always argue that the government flip-flopped on this issue. However, the courts are not going to go with government policy. They'll always go with government regulations. Okay. I hope that helps. Star 5, if you have a follow-up question on this. Okay. Anyone has any question, please press star 5. Anyone has any question, please press star 5 and I'll take you in the order that you logged in today. So far I have 8 people. All right, let's see. So far I have 8 people. Guys, are you sure no other questions? Everybody else is just hanging out? Okay, that's fine. All right, let's go to the 8 questions one by one, or 9 questions now. All right. The first one is area code 484, which was from Pennsylvania. I'm going in the order that you logged into the call, okay? So let's see if I can find, how the heck do I, oh yeah, show queue. Then I go to, I go to 484 and I go select. Hi, go ahead please, I can hear you. Pennsylvania 484, go ahead.
Hi sir. I'm from earlier. I was the first person before this conference was calling. I just wanted to know, how do you know if that employer is legit or not?
I would Google it.
I see
That would be the first
Secretary
thing.
of State.
Yeah, I would Google it. Make sure that the employer doesn't have a prior history of trouble with the government. Ask around. I mean, unfortunately, that's the best I can tell you. So if the employer does not have any prior negative history, I'm hoping that you should be fine.
I see that some of the H-1Bs are approved from this employer.
It's not so much the H-1Bs. Some of these employers are well known to the government. Okay. So, but if they don't have a negative history and you actually worked for them, you can get a letter from them. But if you never worked for them, another thing you can do is, I just thought of that. So another thing you can do is you can say that, look, I joined them, but they never gave me a job and I never got a pay stub from them. I never did anything from them. So therefore it is 90 or 60 days of doing nothing. So you can consider me to be out of out of work for those 60 days. But don't try to set it up as time that
Okay,
you
I
work.
can mention.
Yeah.
Okay, I can tell them that, and then I can delete that employer.
You
Saying
can
that I joined, but I never got any work.
exactly be truthful. Always be truthful. Just today,
Exactly.
just today, I received a call from a college professor, very well known university. And few weeks back, he had asked me a question, and I told him, tell the truth. Don't try to conceal anything from the government. He called me. He said he talked to no less than 8 lawyers. 7 lawyers said, if you tell the truth, you won't get this. But he got it. Okay. I'm not saying it will work out, but if you tell a lie and you get caught, things will never work out for you. Never. Permanent bar. Okay. So please tell the truth.
Okay.
I think you'll be okay because you have a 90-day grace period. So, you're not doing anything wrong.
First employer, I did work for them. I got the
I
pay
know.
stubs and everything.
I know. First
but
and
they did
third.
not mention what my work on the service letter.
Yeah. As long as you mention, well, I mean, as long as the work was in your own major, again, don't lie about it. As long as the work was in your own major, you're okay. All right.
Okay. Yeah. Okay.
Good luck. All right. Sorry, guys. I'm trying to figure this system out. They changed the graphical user interface. This is very complicated. Give me 1 second. So clear queue, hide queue, hide queue. Okay. Oh boy. That's not what I wanted. Hide queue. I just said hide queue. Okay. Now it's good. All right. Now this is the interface I remember. Okay. Now the next one in the lineup is Jersey City, area code 201. Let me look for area code 201 and find it. 1 second. Oh, these guys have completely messed it up. What was the area code? 1 second, guys. I'm having some trouble finding the controls. Area code 201, 201. This is not showing up in my queue anymore. Oh, that's odd. Can I do this? No. Oh, I can move people up and down in the queue. Okay, got it. Area code 214. Go to 201, sorry. 201, I did that. Now I say select this. Okay, got it. Yeah, got it, guys. 201, go ahead, please. I can hear you.
Hi, Rajiv. I'm on H1B and I have my son who's 16 years old, going to be 17 on H4.
Mm-hmm.
But he's non-verbal, non-moving. He's a disabled dependent, he's a cerebral palsy kid.
Mm-hmm.
So what is his option when he becomes 21?
So what I want you to do is when he turns 21, or before he turns 21, a few weeks before he turns 21, just apply for his B2 status and request the government that because this child is completely dependent upon me, please give him B2 status to stay with me, and then you keep extending that every 6 months. Okay. I've had people in similar situation live in USA for 5, 6, 7 years, no problem. But then after that, they got their green card. I think you can keep doing this for almost forever.
Okay. So is there any documentation needed to show him that he's...
Look, if you can afford to hire a lawyer, what I would recommend is for the first application, first time you file it, hire a lawyer. Then you can use the same application with slight modifications to keep extending it. Okay. Typically, a lawyer will
he be part of...
Sorry?
Sorry to interrupt you. So my question is would he be still part of my green card application?
Absolutely. Why not? Absolutely.
So is there any reason for me to worry? Because this is I've been
No,
worried for this,
no, don't
last 2
worry.
weeks.
Actually, Do you have a piece of paper and a pencil somewhere?
Yes.
Okay, take a note of something I'm going to tell you. I want you to Google this.
Okay.
Google Foreign Affairs Manual. So manual is MANUAL. Foreign Affairs Manual. This is the US State Department Standard Operating Procedures. Okay. Foreign Affairs Manual B2 visa. And give me 1 second. Let me give you the exact language they use. Foreign Affairs Manual B2. Let's take a look at it. So when we go to Control F, I'm just doing, there's a specific language they use. I'm coming to that language. Give me 1 second. I'll give you the exact language. Okay, it's not dependence. So what is it? Living. Derivative. I think it's derivative. 1 second. I just want to make sure I give you the information. Yes. What you should do is do a search for Foreign Affairs Manual B-2 visa. Okay. That will open a page for you, which will be volume 9 of Foreign Affairs Manual, section 402.2, in brackets big B as in boy, and then in separate brackets number 5. Okay. The heading is cohabitating partners, extended family members, and other household members not eligible for derivative status. This tells you exactly your situation. That sometimes people live with you, but for whatever reason you can't file, like for parents you can't file derivative, then you can do the B2 for them. Okay. So when you Google this, it will give you the exact law. You should just read up on it, even though this law is not binding on USCIS, but they accept it. They go with it, even though it's State Department Standard Operating Procedures. Okay? Make sense?
Okay. So, thank you so much, Rajiv.
You're
It was
welcome.
very valuable.
Absolutely. My
Very
pleasure.
valuable. Thank you.
The very best of luck. I am very, very sorry to hear about your son. God bless him.
Thank you.
Bye-bye. Okay, let's go to the next person in my queue is area code 716, which is New York, 716. Let me go and find 716. 1 second. 716, here is 716, 716. Select. Okay, New York, I can hear you. Go ahead, please. Area code 716. Go ahead.
Yeah. Thank you, sir, for scheduling this session. I really appreciate it. So
Yes,
the question is, my employer has filed my H-1B and it is still pending with the USCIS. And the thing is, like, my STEM OPT ended September 30th and with the gap. So right now, for a safer side, I have taken the admission for day 1 CPT and wanted to know, like, should I and the employer, the thing is, like, it's a consultancy and they didn't pay me the salary for the August and the September. And the thing is, right now, like, yesterday I had my CPT orientation. So should I, for a safer side, should I apply for the CPT or should I order the I-20 only with the masters? And because I don't want to start the CPT with my current employer, so should I keep on looking for the new job and then start the CPT with the new employer? And in the meanwhile, like, if the H1 gets approved, then how to transfer the H1 to the new employer without
Okay,
the
ma'am,
pay
you
stub
have a very confusing narrative, which is very difficult for me to answer because you've asked me 7 questions that all go in different directions. First of all, let's begin by sorting your situation out. Currently, you are on OPT, your H1B is not approved, correct?
my cap gap ended September 30th and
Okay.
my H1B is still
Okay.
pending.
So the employer cannot pay you. Even if they want to, they cannot pay you. It's illegal for you to work or to get paid. Number 1.
No, I have stopped working on September 30th.
No.
They didn't pay me for the month of August and September when I was working.
Okay. Now that's illegal and you can recover that money from them. Okay. You can actually file a complaint with the, hold on 1 second. You can file a complaint with the local employment office, which is depending upon which state you work in. You are in New York. I don't remember. I think
No, I am in right now in Indiana.
Acha. So even from India, you can file a complaint, and whichever state you
No,
worked
Indiana.
ma'am, or Indiana. Okay. So Indiana should have its
Okay.
own workforce. You can look at Indiana Office of State Workforce, something like that. And let me just give it to you. Hold on 1 second. Indiana Workforce. Yeah, it is called DWD, Indiana Department of Workforce Development. Okay. You call these people up and tell them that 2 months I worked here and they haven't paid me. These guys will investigate the case. They'll make the employer pay you. It doesn't cost you anything.
Yeah, but the thing is, right now the H1 is pending with them, and
Okay,
they are
yeah.
like threatening me to
Right.
withdraw the H1.
So no, don't do anything. Once you get your H1B approval, then you can file a complaint. Okay. Once you get
And
the H1B
will
approval,
it be possible?
ma'am, listen to me. When you get the H1B approval, immediately file for a change of employers. File and transfer. Okay. And when the new employer says you don't have pay stubs, you show them a copy of the complaint you have filed with the Indiana workforce. That shows that you were ready to work, but they were not paying you. And you actually worked, right?
So it should not matter the pay stub for the
Yeah, it
H1B,
doesn't matter.
right?
We've
For
done many
transfer.
cases like this before. No issue. Most important thing is your H1B should be approved.
Yes.
Okay.
So the thing is, like, should I order the CPT without the
Yeah, I think so.
without the CPT or
Yeah, I think you should do the CPT. I think that is the safest thing for you. Okay.
should I start CPT with current employer, or should I for now like order the I-20 without the CPT and start the CPT after I get the new employer?
I think you should start the CPT once you get an employer who's willing to pay you. But start the course, start the I-20.
Yeah. Should I order it right for now, like without the CPT, and add the CPT when I get the employment?
That is correct. That is what you should do.
Okay.
All right.
Okay. Thank you, sir.
You're
Thanks a
welcome.
lot.
Good luck.
Yeah. Thank you.
Bye. Okay. Next is area code 214, Texas. Texas, I can hear you. Go ahead, please.
Yeah, hi Rajiv. Thanks for doing this service. I appreciate your effort.
Sure.
Yeah, Rajiv, I have a quick question. The question is like I just laid off on August 2nd, and I have a severance pay until up to 60 days. But the problem is they started my severance pay from August 15th. So until August 2nd, I had my pay stub running. From August 15th, I had my the severance pay package running through. The 13-day gap they did because of the internal process to start the severance pay. They did the 13 days of gap, and I had my insurance going through during the end of the August. The whole month of August, I had my insurance. So right now the question is, am I in grace period starting from October 30th or September 30th? That means October 15th they had my pay running. That means
No.
October 1 to October 30th.
Hold on. You stopped working on August 2nd, correct?
Yes.
You had your regular pay coming up to which time? Regular pay, not severance.
Up to August 2nd.
Okay. I think you should begin your H1B 60-day grace period from August 2nd. Okay.
Okay.
There are two reasons for that.
Mm-hmm.
One is the gap that bothers me, and two is sometimes government takes the position that severance pay is not really pay. Okay. Now, if you were getting severance pay, was it the full salary under H1B or was it less than that?
It's full salary.
Yeah, I think you could argue that I'm still in 60-day grace period. There is some ambiguity here, but if you want to be safe, I would say count from August 2nd. If you want to be aggressive, I would count it from October when the severance pay ended. Okay, so it depends upon how aggressive you want to be. All right.
Okay. So the government will consider August either from August 2nd or August to October 13th.
Yeah, I would. If I had to fight this case, I would say, not my fault, guys. I'm getting paid. I'm getting paid all the way to October. So my grace period should begin from there, and that's what your current policy says. Your current policy clearly says we will not consider you to be in the grace period until your pay periods have expired. My pay period expired in October. ठीक है ना? So if you had to argue, that's what I would argue.
Okay, so do I need to send a letter or something while filing for a new, once I find a new employer and once they start doing the H1 transfer?
You take it up with your lawyers who do the H1B. Let them decide.
Let them fight. Okay.
Yeah.
Thank you. Thanks, Rajiv.
You're welcome.
Thank you. Bye.
Good luck. All right. So let's go to, man, this graphical user interface is so useless. I am running around. Let's see. Kansas is next. Kansas. Kansas, you are in area code 316. Go ahead, please. Area code 316. Go ahead.
Hello, sir. This is Praveen here. I have a question regarding naturalization process.
Okay.
I am eligible for applying for citizenship, but I have a minor criminal case pending in India.
Is it one of those dowry cases?
So, no, it's not dowry cases, but it's related to matrimonial dispute.
Okay. All right. So, I can't really give you much advice because typically dowry cases we have won. We have won naturalizations and green cards even when the dowry cases were pending. Okay. But other cases...
fake case.
Yeah, well, fake or otherwise, I mean, it's got to be dealt with. So, I mean, you can try, but there may be a problem with naturalization. It's hard for me to predict. You can try. Maximum the government can say no. Nothing else will go wrong. But if you can get the case decided and dismissed, that would be the best thing. Okay.
Okay, so you suggest wait till the case is...
It's difficult for me to suggest one thing or the other. I think you could take either option. You could try to convince the government it's a fake case, but that's difficult to kind of, outside of a dowry case context, it's difficult to prove those things. Okay.
Okay.
Good luck.
So do you think I should... hello?
Yeah, I'm listening to you.
So do you think I should explain it in a...
Yeah, I've already given you my...
I have already
given you my answer. I've said it is your choice. You can go either way. Okay.
Okay.
You can choose to wait or you can apply now. If you apply now, what is the maximum that will happen? You will lose the case, they'll deny it. They are not going to do anything more than that. Okay.
Okay.
And you can always reapply after the case is dismissed.
Okay.
All right. Good luck, sir.
Thank you.
You're welcome. Bye.
Thank you.
Yeah, sometimes, often in law, there are no clear answers. We are always making an informed choice and, taking a risk one way or the other. So we still have about 5 more questions left. Next one is Ohio. Let's see, 614. This is 614. Select. Did I select? No. Select. Ohio, go ahead. I can hear you. 614.
Hello, Mr. Khanna. Thank you for taking this call.
Yes, sir. Go ahead.
I have two questions. I'll start with number one. I want to bring my in-laws into US and want to apply their B2 visa for them. What is the current wait time for visa appointment in India, and what is the best strategy for their this process?
Strategy is always
they cannot go outside India.
Yeah, strategy is always the truth. Waiting time, I don't know off the top of my head. Last time I checked, it was over a year. But people are getting
still
their
now over a year.
Yeah, so it's over a year. Can you apply through a third country? Yeah, B2s are a little difficult to apply through third countries, but technically you can apply in any country. There are people who are going through these travel agents and all, getting their appointments out of turn. I don't know how they are doing it. As long as it is not done illegally, I'm okay with it. Otherwise, you have to wait whatever time it takes.
Okay.
What other
The
question?
next question is about an NOIR. I received an NOIR last year, and I think it was by error from USCIS, and it is resolved now. USCIS confirmed an email and the letter.
Excellent. All right. So
now the question is, will that be an issue while I travel to India and come back?
No. That was just issued. You never had a denial, so why should that be a problem? Not an issue.
Sometimes USCIS.
No. Oh, don't worry about that. You should be fine.
Okay. I do have some responses from USCIS that this was an error. Please ignore.
Yeah. That doesn't surprise. That doesn't surprise me. USCIS works in mysterious ways. Not to worry.
I just have to keep this copy. Just in case anything they ask for.
I don't think, because their records would be clean by now, so I don't think you can have a problem at all. All right.
Okay. Thank you.
You're welcome, sir. Anna. Good luck. Okay. Let's go to the next one, which is area code 660. 660 is from Missouri. Okay, let's get Missouri. 1 second. Missouri, I can hear you. Go ahead, please.
Hello, Rajiv sir. I have a couple of questions. So I currently was affected by the layoff. I'm on H1B and currently on 60 days grace period. Only 1 month is left. So I'm wondering what is the best option? Is it kind of change of status to B2 or F1?
Well, if you want to go to school and you want to study, then F1. But if you just want some time to look for a job, then B2.
So is it easy to go back or okay to go back from B2 to H1? Will there be no problem?
No, we do it all the time.
In future?
We do it all the time. This issue has been discussed very thoroughly in our frequently asked questions. So yeah, it's no issue going back from B2 to H1. It's fine. Worst case scenario, you may have to go get a visa stamping. So it's not the end of the world.
I do have visa stamp, so it will just resume that remaining H1 period.
Then it's even easier. If you already have a visa stamp and something goes south with your H1B, all you have to do is take the approval, step out and come back with the old stamp and the new approval. So I don't think you're going to have any problem, ma'am.
Okay, so it's better than going to F1 and then leaving school in the middle.
I answered that question. I answered that question in the first line I spoke. I said if you want to go to school, then do an F1. If you don't want to, and you just want to look for a job, then stay on B2.
Okay, thank you, sir. And I also have a friend with me who has a question.
Okay.
If you don't mind.
All right. Go ahead, friend.
Hey, Rajiv. Hey, can you hear me?
Hanji, I can hear you. Go ahead.
Hello?
Yeah, I can hear you.
Okay.
Go ahead.
So there is a question. So basically, I'm currently
I'm currently working with a non-profit organization on an H1B non-profit. But this year I got an opportunity with an employer B, which is like a profit organization.
Okay.
They put my start date to October 1st, but they never informed me by late September.
Okay.
So I kind of told them to get my employment by November, but they recommended me to start by January 1st. So I have a question. Is it okay to start by January 1st, or is it going to affect any of my
Okay.
visa status or anything like that?
Back up a little bit. There's insufficient information. So, did you win the lottery? That's the first question.
Sure. Yeah, I did.
Okay. So, when they filed...
I did, and they also got me 797. Yeah.
Acha. So, and they got it with the I-94 attached, correct?
Yes.
Hello? Hello?
Hello? Yes.
Yeah. So, did you get the I-94 attached as
Hello?
well? Sir, I can't hear.
I-94, I'm currently in States, never left.
Okay,
my I-94 is been with my non-profit organization.
Yeah, so when the approval came with the new employer, there should be an I-94 attached at the bottom. That the original should have been given to you. So before you ask me any other questions, go and check if they've got the I-94. Okay?
Okay. I don't have the I-94. They just sent me a PDF copy of 7979.
So at the bottom of that PDF copy is there an I-94 attached. So I-94 is usually torn off.
I might have to check that.
Yeah, they have to tear it off and give it to you. You need the original. Okay. So I'm assuming that you have the I-94. So what is the start date on your H1B?
Yes.
What is the start date on this H1B?
It's October 1st.
Yeah, can you start on January 1st? Sure. If you have some reason that you could not join...
Yeah, they are asking me.
Go ahead.
So they gave me like an October 1st start date, but now they are pushing it to January 1st.
Okay.
So since it's like a 3 month gap, I don't know like what to do.
So the law allows the employer to accommodate the employee. Okay. So even if you needed 4 months extra, you could take them. The employer can choose to accommodate you. Okay. But the employee cannot be required to accommodate the employer. That's the law. So if you show up the day your 797 is approved, you say, I'm ready to work, the employer has to start paying you right away. That's the law. Okay. So if this was done at your request for your benefit for accommodating you, it's perfectly legal. If they are trying to play hard and fast with you, they can't. Remember, you don't have to join them. You've got your approval. You're out of the lottery. You can always look for another employer. Okay?
Oh, okay. So in that scenario, let's say if I don't even join that employer and if I find a new employer,
you can transfer, in my opinion.
Can I just change from non-profit to profit?
Absolutely. Because you already won the lottery, you got the H1B approval.
Oh.
Okay.
Okay. I thought like since I would never start with employer B, which is like the profit, I thought like I would have to go back again to lottery.
No, there's no such law. Okay.
Okay.
Yeah, just make sure that you've got your I-94 at the bottom.
Thank you so much.
Yeah. Sorry? I'm going to have
and when is the I-94? That's through the new employer, right?
Yeah, through the new employer. That's important. Okay. If you don't have the I-94, join me in the next community conference call. I've got to go to my next call, okay?
Sure. Thank you so much.
You're welcome. Good luck. Okay, now we are back to Maryland, 240. 240, go ahead. I can hear you.
Hi, Rajiv. So I'm a permanent resident in the US, and I got married in May 2022 to my wife who lives in Nepal. She has never been to the US.
Okay.
Right. And we filed for her I-130 in June of 2022.
Okay.
And it's taking very long. So in the meanwhile, we applied for a visitor visa, and that got denied in June of 2023. My question is, she has a next appointment coming because that's also taking very long. The wait time is 1 year, so it's coming in 2024 June. So what can we do to improve her chances? Because the I-130 now it's saying 32 to 36 months.
No, you can't do anything to improve her chances. I have another case exactly like yours from India where they just got the tourist visa approval. Exactly your case.
Okay.
So they are very inconsistent. It's very difficult to say what will work, what will not work.
Yeah. They asked her if anybody had applied for her I-130, and as soon as she said yes, they said you do not qualify.
Yeah, well,
and this can take 3-4 years.
My client in this case that I was talking about, which got approved yesterday, they were asked the same questions, and not only was the tourist visa approved, it was approved for 10 years, which was unexpected. I thought they'll approve it for 1 year maybe.
Okay.
But they gave her a 10-year visa. Okay, so it's very inconsistent. Not much I can tell you other than wait and watch and see what happens.
Okay.
She qualifies for any other visa, H1B, etc. You can try that, but otherwise there's not much we can do.
And not F1 also, right? There's big chance of F1 also being denied.
Mushkil hai. They are, once they have denied on 214B grounds, which is what the grounds would have been, it's difficult to overcome them in B2 or F1 visa context. Okay?
Okay.
Good luck. All right. Bye-bye.
Thank you.
You're welcome.
Bye.
Let's go to California, and after that we have only one more question. So California, go ahead, please. 408.
Yeah. Hi, Rajiv. I have a quick question.
Uh-huh.
So, my brother got H1 got approved when he is in India.
Okay.
And on an employment purpose, he is right now in Australia.
Okay.
He's trying to go to the stamping. Is it recommended to go in Australia, or is it recommended to
I
go
would do it in
India?
Australia. That's where he's living. Absolutely. Go for it in Australia. Okay.
Okay, but when he got the approval, he's in India. So his employer
Yeah, see,
saying that it's
what
recommended
happens
to
is
go to.
in the approval or in the petition, we can say we want him to go to Mumbai. Okay. But let's say he happens to be in UK or Australia. He can apply there even though the paperwork says it's gone to Mumbai. See, this is a remnant of the old procedures because now everything is in the cloud. Every consulate has access to the same information. There's no more paper files.
Okay.
Good luck.
Yeah.
All right.
Yeah, thank you.
You're welcome. All right, guys. Last question of the day is from Texas, I think. Area code 214. Go ahead, please. Texas.
Yeah. Hello, Rajiv.
Hello, sir.
My question is, I have been working for employer A in the past. I got my I-140 filed and approved. So my priority date is from March 28, 2012.
Okay.
Then I moved to employer B. Employer B also filed my perm, my I-40, I-140. They both got approved. But because my priority date of 2012 was not current, they could not find my 485.
All right.
Then I moved to employer C. And right now I'm awaiting my perm to get approved.
Okay.
My employer B and I have been on good terms.
Okay.
And they are willing to file my 485.
Okay.
So the question I have is, should I go ahead with them? And then I had a question regarding if they file my 485 with employer B, how does the 180 day get counted? Because I'm not currently working for them, right? I'm working for employer C.
There are a lot of difficulties with this scenario. If it doesn't get questioned, it will go through smoothly. But if it gets questioned, two questions that are very difficult to answer. Number one, you were working for employer B. It was supposed to be a permanent job. If it was a permanent job, why you, Mr. Employee, left? Number one question. Number two question, Mr. Employer, you offered him a permanent job. When he left, who was doing that job? Okay. So these two are difficult questions to answer, and they can be unique to every case. I don't really know your case. You should talk to your lawyers, figure out these two questions. If these two questions are answered satisfactorily, absolutely. If you have the intention to go back to that employer and they have the intention to take you back, great. File the 485. What happens is, from the date the 485 is filed, the 180 days begin. Okay? Because your I-140 is already approved. So the 180 days begin on the date the I-485 is filed. After 180 days are done and gone, you are not obliged to join that employer. You can join any employer as long as the jobs are same or similar. But on the date you filed, you must have the intention to go back to them. They must have the intention to take you back.
Okay. So with employer B, like if my green card gets approved through them, they are willing to offer me the position, and I'm also willing to go back.
Yes, then figure out the other two questions with your lawyers and take it from there.
Okay. One last question. I didn't think about the scenario you talked about. Like basically, once the employer B files 485 and 180 days passes by, after that I don't have to take that job, right?
That is correct.
If that, let's say, if that situation happens, 6 months pass by, 180 days pass by, and employer C, now they don't have to wait for perm. They can just file I-485J.
That is
correct. That's what I decide to do.
That is correct. Okay. But all these things should be discussed with your lawyers in detail. You should have a good half an hour, 45 minutes, sit down with the lawyers. Make sure you've discussed every possible angle. I have done these kind of cases time and time again, but I never do them without understanding the whole situation. Getting the employers involved, making sure everybody understands what is going on. Theoretically and legally, this is perfectly okay. All right?
I see. Okay. And I mean, so my 140 was approved with employer B, and then if we file the 485 with employer B, there will be a gap of almost 3 years in between. Do you think that would be a problem?
No, I've done cases like this before. As long as these questions are answered, you'll be fine. All right.
Okay. Thank you, Rajiv.
Good luck.
Much appreciated.
You're welcome. Bye-bye.
Thank you.
Okay, folks, that brings us to a close of the questions today. I'll see you next Thursday on LinkedIn. Take care, everyone.